I've said before, and I'm going to talk about it later in the program, but you'll never see a white flag flying in front of the FRC headquarters. I don't care. Court decision, no court decision, legislative action, no legislative action. The militant left does not matter. We will not surrender 1 inch of ground when it comes to the truth. I'm going to talk more about that later. But first, in what is just a shocking decision by the Supreme Court, a 6-3 ruling on Monday in the Bostock case, in which the court effectively redefined the word sex by a 6-3 majority. Now, what are the implications for this regarding religious liberty? Are churches now at risk? Religious organizations, Christian businesses? How far-reaching is this decision? Joining me now to answer these questions, former clerk for Justice Alito and a member of the Senate Judiciary Committee, Utah Senator Mike Lee. Senator, welcome back to Washington Watch.
Thank you so much, Tony. It's good to be with you.
Your reactions to the Supreme Court's decision that was handed down Monday, redefining the term sex?
Well, it's disappointing. I disagree with it. Justice Gorsuch took a meat cleaver to the issue of how the Civil Rights Act of 1964 should apply to LGBT individuals. And now, as a result of taking a meat cleaver to this issue, it's resulted in a lot of blood spilling everywhere, and metaphorically speaking, of course, and now we're working on a legislative solution to try to figure out how to clean up the mess. But the biggest problem with it was that he made a legislative determination. He effectively rewrote the law. And when you rewrite the law through a judicial opinion, that's a very crude way in which to operate. It's not precise, and it leaves completely undecided all sorts of questions regarding the permutations of this and the implications, some of which you referred to, for religious institutions, churches, church-owned enterprises, and religious individuals and proprietors. These questions have to be answered, and yet the court didn't bother to answer any of them.
But the court did acknowledge that this decision would create further cases. I mean, they essentially said this decision is going to make a mess, but we leave that for another day.
Right. And unfortunately, what that really means is we're going to leave that for a lot of other days. As I was commenting to someone the other day, I'm a third-generation lawyer. I've got 2 sons in law school who are going to become fourth-generation lawyers. I'm convinced that not only my children, but my grandchildren's generation will still not see the end of litigation resulting from the Bostock decision. Because when you take this kind of a meat cleaver to federal law, it's going to take not just years, but decades to iron out all the details, and there are going to be some real heartbreaking stories in the wake of it.
I want to go back. As a member of the Judiciary Committee, your committee is the one that hears the judicial confirmation, or that goes through the judicial confirmation process for the nominees. I have a clip of Judge Gorsuch at the time, now Justice Gorsuch, discussing this very thing. Play clip number 1, please.
Justice Scalia was a mentor, too. He reminded us that words matter, that the judge's job is to follow the words that are in the law, not replace them with those that aren't.
A true statement?
It's a true statement. I wish he had followed it. I wish I could have put that on record and then played it on a continuous loop in his office ever since we made the decision to confirm him. Look, this sort of ruling was not what we had in mind when we confirmed Neil Gorsuch. This is not what we had in mind when we heard a judge speak passionately and see his 10th Circuit opinions, of which there were many, that echoed that same sentiment, that the judge's job is not to remake the law. It's not to legislate. It's to decide what the law as enacted actually says and what the public understanding of it was at the time of its enactment.
So, Senator Lee, did he deceive the committee when he sat there and made that statement?
It's not my place to say whether he deceived. I can't get into another man's head. I can't know the thoughts and intentions of another human being, whether a jurist or otherwise. And so that's between him and his maker to decide whether or not that was a deceitful statement at the time. What I can say is what I understood from that is not consistent with the opinion that he issued yesterday. Now, or day before yesterday, the opinion he issued day before yesterday tries to use the trappings of textualism, which is just a fancy word for saying we as judges should interpret the law based on what it says and based on its original public meaning at the time of its enactment. So I can't know what he subjectively meant, but what I do know is that he didn't follow the textualism he was purporting to apply.
Well, certainly. I mean, can you trust a man to define textualism who cannot define sex?
Yeah, and who gets so wrapped around the axle while purporting to apply textualist rules, gets so wrapped around the axle that he comes up with an interpretation of it that is tortured, that's internally inconsistent, and that is utterly at odds with the contemporaneous public understanding of this law at the time it was enacted in 1964.
So, Senator Lee, I mean, I've known you for a long time, and you have been one of the most consistent voices on textualism, on the Constitution, on upholding it. You've written on it. You've spoken on it. Let me just be very blunt. This is demoralizing to a lot of people who were hoping that the court would return to its constitutional boundaries and not legislate as they did on Monday in handing down this decision. What is the way forward from here?
My hope, and frankly my expectation, but definitely my hope, is that this might be an aberration for Justice Neil Gorsuch and to a degree for Chief Justice John Roberts. I'm deeply disappointed in both of them from issuing this decision. I think it's wrong. I understand how they got there because they explained publicly how they got there. The problem is how they got there simply isn't satisfying. It's not compelling. That's actually what the words mean. I can hope only that this will be an aberration and not an ordinary course of business for them. As my late father used to say, everyone's entitled to a mulligan now and then. Now, this one's a big one. This is a big mulligan. But I don't know what other choice we have here. One of the important things to keep in mind, Tony, is that this is why we've got to continue the effort to bring textualist originalist judges onto the bench, including onto the Supreme Court. The American legal education system and the American legal profession and our society doesn't automatically churn out conservative thinkers or textualists.
True. Yes.
And so the default is for them to be liberal and purposivist, meaning an outcome-oriented sort of policy-making type of thinkers. That's one of the reasons why this battle is so important, because even the people who purport to be with us sometimes are not.
Well, in my experience, Senator, is that in the time, almost 20 years that I've been in this process, that, you're absolutely right. The default is not what we want. But we've got to go beyond just taking people kind of at their word. I think we've got to begin looking for records. We've got to be looking for those solid stances on those positions of being constitutionalists. And we've been told so many times by different administrations, they're going to be right, even though they have no record, because it's too hard to fight for someone with a record.
Yeah, no, that's right. And that's one of the reasons why I think it's such a big mistake when these vacancies do occur for us to go with an easy path, to go towards somebody without a record. Now, in the case of Gorsuch, he had a record, and I spent an ungodly amount of time going through every opinion I could get my hands on. He had a decade's worth of good jurisprudence. I didn't find a real horrible one among them. And so this one took us out of left field. But you're exactly right, Tony. This is all the more reason for us when these vacancies occur. We cannot take chances.
Yeah.
There's too much on the line. There's too much they can mess with. When they can remake our law in their own image, when they can supplant the role of the legislative branch with the stroke of a judicial pen, that is lawlessness. We can't allow that to happen. We cannot take chances anymore. Never again.
Senator, before I let you go, this, in the wake of what I call shell shock, because people never expected this, your Democratic colleagues are trying to fast-track a piece of legislation which would go even further than this court decision, which is the Equality Act, H.R. 5, which passed the House, reportedly could be voted on in the Senate or moved forward as early as tomorrow.
Yeah, well, that's not going to happen. And the reason it's not going to happen is that this is a sort of Orwellian name that they've attached to this legislation. It's one of the favorite tricks of the left is to come up with legislation that has a title that sounds nice and doesn't sound at all menacing. If you came up with a bill that was called the Let's Protect Cute Puppies and Kittens Act, nobody's going to want to oppose that because the title sounds nice. Equality Act sounds nice until you stop and examine what it would actually do, what it would do to religious institutions. The fact that this would openly threaten religious institutions and individuals throughout America who dare have divergent views, who dare act in conformity to their religious beliefs, this would end up having a punishing effect on them, to say nothing of what it would do to women's athletics, what it would do to girls' and women's locker rooms and restrooms in colleges and in public places. It's just scary.
Yes. Well, Senator Mike Lee, I want to thank you for being one of the staunchest defenders of the First Amendment on Capitol Hill, and I want to thank you for joining us today and providing some insight.
Thank you, Tony.